Hi and welcome. Have you ever wondered when someone sells a property or gives a property to someone else or mortgage a property to bank? All these are not simple deals. These are governed by one powerful law, that is Transfer of Property Act 1882. It's the Transfer of Property Act acts as a backbone ensuring fairness, clarity and legalities over the property. So when was the transfer of property came into force? It came into force in 1st July 1882. Before that, there was no single statute to guide how a property can be transferred in between two persons. The main objective is to bring the transparency and uniformity in the transfer of property across India. It also guides to whom the property can be transferred and under what conditions the property can get transferred. So, what exactly is this Transfer of Property Act? According to Section 5 of this Act, the transfer of property is an act by which a living person can convey his rights in the present or in the future to another person or to himself through a legal document. In simple terms, it is when the ownership or the rights over the property is handed over to another person in a legal manner. However, there are five essential elements that need to be met for the transfer of property. Number one, there has to be two living persons to execute the transfer of property. It means neither wills or inheritance would not be accepted for the transfer of property. Number two, the person has to be competent and sound minded. It means that the transferor of the property has to be in sound mind and capable to transfer the property. It means he should be in sound mind and he should not be a minor during the transfer of property. Number three, it has to be executed clearly with legal intention. Number four, there has to be a legal documentations and a registration process that need to be executed. Number five, the property which is being transferred must not be restricted by any law. These are the essential elements that need to be met for the transfer of property. So, what type of transfers can we observe in this following act? Generally, there are several. One of those are number one, the sale, a clear intention of selling a property for a price. Number two, mortgage, keeping a property under a bank for a loan. Number three, exchange of property. The property can be exchanged between two parties. Number four, lease, a temporary transfer of the possession for the rent purpose. Number five, gift, a voluntary transfer of the property without any consideration is called as gift. Each of these transfers are having certain conditions and procedures under this following act. What properties cannot be transferred? Interestingly, there are certain factors that a property cannot be transferred. These are mentioned under Section 6 of this Act. A chance of right to inheritance of the property, a right to re-entry or claiming future maintenance, or mere right to sue. So, what is the importance of this Act? This Act legally ensures that the rights of the buyer and the seller are legally protected. All in all, it also prevents the fraud and dispute transfers of the property. In short, it forms the foundation of property law in India. In the upcoming videos, let's break down all the mode of transfers in this law. For further videos, like, share the videos and subscribe for the Legallex.